Good afternoon, everyone. Welcome to our April Bank Council Roundtable. This month, we're going to have 3 topics, all of which are timely. The first is electronic UCC amendments, or more specifically, UCC amendments to accommodate electronic assets. This, of course, is something I have no understanding of, but Erin Bryan is here and she does. So she'll be making that presentation. Then we'll talk about the Federal LIBOR fix, which was finally enacted and gives lenders who don't have good interest rate substitution language in their documents a way to move forward and avoid liability. And then finally, Betsy Parker will be presenting that part of the webinar. And finally, TILA state law disclosure requirements, part of our continuing presentation on the socialization of business lending, and Joe Liniak will handle that. So without further ado, I will turn it over to Erin.
Great, thank you, Tom. So just a few housekeeping notes as usual. Materials and attendance forms are available for download in the reminder email that was sent to you from Dorsey U. We will not have time today for Q&A, but you can contact any of the speakers directly or reach out to your trusted Dorsey contact if you have follow-up questions. We will be announcing a CLE code during the presentation, so attendees in states that require a code should make note of that. We've listed the states where CLE credit is expected. If you want credit, please complete the attendance form and send it to attendance@dorsey.com. Right. So today I will be discussing the recently proposed UCC amendments relating to electronic assets. The Uniform Commercial Code, or UCC, is a product of the Uniform Law Commission. The Uniform Law Commission is 130 years young. It's a nonpartisan organization established to bring clarity and stability to critical areas of state law. In 1942, the Uniform Law Commission joined up with the American Law Institute to begin drafting a uniform commercial code. The goal of the UCC from the start was to promote cross-jurisdictional consistency and predictability in the laws of sales and commercial transactions. The UCC was first published in 1952. Pennsylvania was the first state to adopt the UCC, but over the following decades, there was widespread adoption. As of today, the UCC has been enacted in the 50 states, plus the District of Columbia, Puerto Rico, and the Virgin Islands. However, there have been some local variations. For example, Louisiana did not adopt Article 2, while many states have adopted alternate language for some provisions. The UCC primarily focuses on commercial transactions, but it does include some consumer protections as well. As a quick refresher, this slide lists the current articles of the UCC. Article 1 contains general provisions, while the remaining articles deal with particular categories of transactions. So now that we've set the stage, let's turn to some more recent developments. As we all know, over the course of our lifetimes, there's been a digital revolution that has changed commerce in ways the UCC's first drafters never could have imagined. In response to the increasingly complex array of electronic assets, we've seen emerging technology laws popping up around the United States. Over the last few years, many states have begun to enact laws to respond to blockchain, cryptocurrency, NFTs, and other digital assets. Perhaps the most well-known of these state efforts is Wyoming, which has enacted groundbreaking laws on blockchain and decentralized autonomous organizations, in addition to setting up a fintech regulatory sandbox. Some states have also amended their UCC statutes to reflect the existence of digital assets. Additionally, in 2020, nearly every state legislature is considering laws related in one way or another to crypto. However, the patchwork approach can lead to inconsistency in governing laws and unpredictability for interstate commercial transactions. So, against this backdrop, in 2019, the ULC and ALI appointed a study committee to consider whether changes to the UCC are advisable to accommodate emerging technologies such as artificial intelligence, distributed ledger technology, and virtual currency. The Joint Committee has also reviewed additional topics concerning emerging technology, like digital assets, payments, and so-called bundled transactions, which refers to transactions that involve the sale or lease of goods together with the provision of services, the licensing of information, or both. The Joint Committee met over the course of 4 years. I've attended many of the virtual meetings over the past 2 years as an observer, and it's been enlightening to hear the academic and practical discussions of these issues. While it's a given that no drafting project of this magnitude will satisfy all critics, we should at least acknowledge that the committee has made great efforts to include as many constituencies and perspectives as possible and to address various concerns. They have also attempted to take a technologically neutral approach. In other words, they have tried to draft in a way that will allow the UCC to enable future unknown innovations. This was the approach taken by the drafters of eSign and UITA. Essentially, build it and they will come. Time will tell whether this approach will prove successful for the UCC. This slide provides a timeline of the remaining tasks of the drafting committee. The committee's work is nearing completion. In May, the ALI will consider approval of the draft amendments. And at this point, the Joint Committee is expecting approval. Then in July, the ULC will have its required 2 readings before considering final approval of the amendments. The American Bar Association will also review the amendments. Once this process is complete, the educational and lobbying efforts will begin in an effort to encourage widespread and uniform adoption of the amendments. And I have kept you in suspense long enough, so let's turn to the substance of the amendments. The only article of the UCC not affected by the amendments is Article 6, bulk sales. Every other article of the UCC faces proposed revisions. In many cases, the changes are to update words such as writing or written to technology neutral terms such as record. My goal here is not to be comprehensive about all of these revisions, but to highlight amendments that are relevant specifically to emerging technologies. If you practice regularly in one or more of the UCC governed areas, I would strongly encourage you to review the red line of the amendments that is currently available on the Uniform Law Commission's website. Of relevance to us today, in Article 1, the definitions of conspicuous, money, and signed would be amended. The term conspicuous becomes confusing when discussing online or electronic disclosures. So there's an extensive rewrite of the definition as well as comments to address electronic formats. For example, what does it mean to have a certain size of text if everyone's screen displays it in a different format? So those revisions are designed to bring that into the modern era. The drafters also concluded that the term money as drafted would already include a government-issued cryptocurrency, but they've tried to slice it in a way that existing crypto, such as Bitcoin, would be excluded even if a government later approves it for official use. Articles 2 and 2A would be revised to address so-called hybrid transactions, where a single transaction involves the sale or lease of goods, plus either the provision of services, sale or lease of other goods, or sale, lease, or license of property other than goods. Article 3 would be revised to better address electronic checks and check conversion issues. And the same with Article 4. Article 4A, meanwhile, has extensive revisions concerning payment orders and security procedures. Article 5 is amended in only one place, which is governing law, to address the location as it pertains to bank branches. Article 7 would be amended to address control of electronic documents of title. And Article 8 would be amended to specify that a controllable electronic record may be a financial asset credited to a securities account. Now we get to the really big changes. We could easily fill an hour just talking about the proposed amendments to Article 9 and the brand new Article 12. Here are a few highlights to get us started. In Article 12, the word authenticated will be replaced with signed, since signed is now defined in Article 1 in a way that is inclusive of electronic signatures. The terms assignor and assignee are now defined. The proposed amendments would revise the definition of chattel paper to mean a right to payment rather than a record evidencing a right to payment. And the remaining changes are primarily to create harmony with the new Article 12, which I'll turn to now. The new UCC Article 12, Controllable Electronic Records, contains 7 sections, including the relationship to Article 9 and consumer laws, rights and controllable accounts, controllable electronic records, and controllable payment intangibles, control of controllable electronic records, and discharge of account debtors on controllable accounts or controllable payment intangibles. The new UCC Section 12102 contains 4 definitions, each of which is key to understanding the article. First, controllable electronic record. This means a record stored in an electronic medium that can be subjected to control under Section 12105. And I'll go into the details of that in a minute. This definition is significant for what it does not include. The term does not include a controllable account, a controllable payment intangible, a deposit account, an electronic copy of a record evidencing chattel paper, an electronic document of title, electronic money, investment property, or a transferable record. The last item in that list of exclusions, transferable record, is defined in reference to e-sign and UITA. Qualifying purchaser is defined to mean a purchaser of a controllable electronic record or an interest in the controllable electronic record that obtains control of the controllable electronic record for value in good faith and without notice of a claim of a property right in the controllable electronic record. Value is defined by reference to UCC Section 303A. Section 12103 provides that in a conflict with Article 9 will govern. With respect to security interests, UCC Section 9203 will determine whether a secured party has an enforceable security interest in a controllable electronic record. A key point here is that under Article 9, perfection of a security interest in a controllable electronic record, controllable account, or controllable payment intangible is established by control or by filing a financing statement, but for priority purposes, a security interest perfected by control will have priority over a conflicting security interest perfected by filing without regard to timing. Also note that Section 12103 provides that in a conflict between Article 12 and consumer laws, the consumer laws will govern. The new Section 12104 addresses rights in controllable accounts, electronic records, and payment intangibles. It provides that a qualifying purchaser acquires its rights in the controllable electronic record free of a claim of a property right in the controllable electronic record. This is modeled on Article 3's holder in due course provisions. A purchaser will be a qualifying purchaser of a controllable account or controllable payment intangible if the purchaser obtains control of the controllable electronic record that evidences the account or payment intangible. Significantly, filing under Article 9 does not provide notice for purposes of the protections available to purchasers under other articles of the UCC. Section 12104 does not address how a transfer of rights is effectuated or what rights the transferee acquires. However, the so-called shelter principle will apply, meaning that in general, the transferee receives whatever rights the transferor had or had the power to transfer. Section 12105 is the heart of the new Article 12. It lays out the framework for determining whether a person has control of a controllable record. There are three ways to establish control. The first is the most complex. Under 12105A, control is established if each of the following criteria is satisfied. You may want to read along while I go through this because it is rather complex. So here are the criteria for that first formulation. The electronic record or a record attached to or logically associated with the electronic record or a system in which the electronic record is recorded gives a person the power to avail itself of substantially all the benefit from the electronic record and gives the person the exclusive power to prevent others from availing themselves of substantially all the benefit of the electronic record and gives the person the power to transfer control of the electronic record to another person or to cause another person to obtain control of another controllable electronic record as a result of the transfer of the electronic record and the electronic record, a record attached to or logically associated with the electronic record, or a system in which the electronic record is recorded enables the person readily to identify itself in any way, including by name, identifying number, cryptographic key, office, or account number as having those powers. Now, I know that that was a lot of text, but those words are incredibly important. So I didn't want to summarize it until after we'd had a chance to look through it. So I'll pause for a moment here and put it another way. So if we were to summarize this, I would say that the key questions here to this determination of control are who has the benefit of the record, who has the power to transfer control of the record, and whose name is associated with the record. In addition, there are two other ways to establish control. A person has control of a controllable electronic record if another person other than the transferor of an interest in the electronic record either has control of the electronic record and acknowledges that it has control on behalf of the person, or two, obtains control of the electronic record after having acknowledged that it will obtain control of the electronic record on behalf of the person. Why does control even matter? Well, the drafters state that control is intended to be a proxy and a functional equivalent of the transfer of physical possession of the goods. They also note that an electronic record is a controllable electronic record as defined here and is subject to the provisions of Article 12 only if it can be subjected to control. So the control test is incredibly important. And only a person having control of a controllable electronic record is eligible to become a qualifying purchaser and so take free of claims of a property interest in the controllable electronic record or any controllable account or controllable payment intangible evidenced by the controllable electronic record, and to receive protection from the no action rule. All right, so if you fell asleep during that, you can wake up now because we're going to go to a slightly different topic. The rule for discharge of an account debtor is similar to UCC sections 3602 and 9406. So an obligation can be discharged by paying either the person having control of the record that evidences the controllable account or controllable payment intangible, or by paying a person that formerly had control of the controllable electronic record. Now, regarding notification issues, if the account debtor receives an effective notification the control has been transferred, the account debtor may discharge its obligation by paying in accordance with the notification and may not discharge its obligation by paying a person that formerly had control. Importantly, the notification must be authenticated by a person formerly having control or by the transferee. All right, for purposes of Article 12, the governing law is the local law of the controllable electronic records jurisdiction, unless an effective agreement determines that the law of another jurisdiction governs. But how do you locate an electronic record? The drafters acknowledge that there are substantial practical limitations in determining the location of a controllable electronic record. Article 12 includes a waterfall that first looks to the express provisions of the controllable electronic record or the system in which it is recorded. However, the drafters acknowledge that many electronic records and systems currently in existence do not yet contain these provisions. The drafters expect that over time, electronic records and related systems will adopt location provisions to create certainty as to the governing law. But I will note that under the waterfall, in the absence of such provisions, the controllable electronic records jurisdiction will be deemed to be the District of Columbia. All right, Annex A to the amendments contains transition provisions modeled off of those used for the 1999 revisions to Article 9. The transition provisions are integral to the analysis of perfection and priority. The drafters opted not to establish a uniform enactment date. Instead, they contemplate allowing state legislatures to determine an effective date based on their own legislative calendars, but to have a uniform adjustment date at least a year after enactment of January 1st or July 1st. The transition provisions include a general savings clause, which provides that a transaction validly entered into before the effective date and the rights, duties, and interests flowing from that transaction will remain valid thereafter and may be terminated, completed, consummated, or enforced as required or permitted by law other than the UCC, as though the act had not taken effect. There is also a savings clause particular to Articles 9 and 12 to address the unique questions of perfection and priority. In closing, I will offer a few considerations for commercial transactions. So first, it's essential that someone in your organization or on your behalf be monitoring the progress of these amendments and their enactments by the states. Second, legal departments should be giving particular focus to the priority, perfection, and transition provisions of the amendments. They are intended to allow contract parties enough time to plan for interim and post-enactment transactions. But given the volume of these changes and the complexity, it would be wise to start mapping the proposed changes sooner than later. Third, as the amendments are potentially enacted by some locations but not others, you will want to consider governing law issues in your agreements and how the potential changes could affect the analysis of which jurisdiction is most advantageous for a particular agreement. Fourth, you should of course review your security agreement and financing statement forms to confirm the adequacy of existing language, particularly if you are taking security interests in cryptocurrencies. My colleagues and I will continue to monitor the progress of the amendments, and we will undoubtedly have future programming on this topic as the amendments potentially move toward enactment. And now I will turn it over to my colleague Betsy Sanders Parker to discuss LIBOR replacement.
Great, thank you, Erin. I think we can move ahead to the next slide. So it's been a few months since I last spoke about LIBOR at one of the Bank Council roundtables. I believe January was probably the last one that I spoke at on this topic. Since that time, there has been a big development on the legislative front, that being the enactment of the Federal LIBOR transition legislation. On March 15th, President Biden signed into law the Consolidated Appropriations Act 2022, which included legislation that will assist with the LIBOR replacement process. The crux of the legislation is that it creates an automatic LIBOR fallback to SOFR in the event that we get to the end of LIBOR and contracts are not equipped with language that provides for a replacement benchmark or a means for determining a replacement benchmark. Today, I will tell you more about the legislation, but before I do, let's talk a little bit about how we got here. Next slide, please. As I'm sure everyone knows by now, on March 5th, 2021, the UK Financial Conduct Authority and the ICE Benchmark Administration announced that all tenors of LIBOR would cease being published by June 30th, 2023. On December 31st, 2021, 1 week and 2 month tenors of US dollar LIBOR ceased to be published. And on June 30th, 2023, overnight, 1 month, 3 month, 6 month, and 12 month tenors will cease being published. As we've all experienced, or at the very least witnessed, while contractual LIBOR fallback amendments have been in process for some time, the certainty this announcement provided launched the financial sector into an additional frenzy to amend once and for all each individual contract that references LIBOR to either establish LIBOR replacement procedures or to switch immediately to an alternate benchmark. Now, while all corners of the financial sector are working overtime to limit the impact of the transition away from LIBOR, the reality is that even with all that effort, there will be contracts on June 30th, 2023 that still use LIBOR as a benchmark. As you can imagine, there could be any number of reasons for this. It could be that the nature of the contract is such that it can't be amended. For example, maybe a publicly held security, or there may just be a large number of holders, making it difficult to obtain the requisite consents. It could be that there are parties that are holding out, trying to get better terms from their counterparties. Or it could be as simple as a contract that simply fell through the cracks, or for which the parties thereto are not particularly sophisticated and don't even know how to do this properly. So recognizing this, there was a movement among states to implement some sort of legislative solution. New York was the first state to enact legislation just about a year ago on April 6th of 2021. These state legislative actions applied to contracts for which the governing law was the law of the enacting state. So, for example, for New York legislation, New York governed contracts. And provided that, as a matter of law, on the date that LIBOR is no longer published or representative, LIBOR would be replaced in those contracts with a rate that used SOFR as the benchmark. Now, obviously, a relatively large number of contracts in the United States are governed by New York law relative to other state law. So the New York legislation was a particularly important step towards resolving the issue of what would happen on June 30th, 2023. Still, in order to have a full solution, every state would need to enact similar legislation ahead of that deadline. And while this is a possibility, there was still real risk that one or more states would not enact such legislation. That risk creates uncertainty. Uncertainty creates more risk and more expense. And so to resolve all the cycle of risk and uncertainty and expense, the federal legislation emerged. Now, on July 22nd of last year, the Adjustable Interest Rate LIBOR Act was introduced in the U.S. House of Representatives and was passed by the House on December 8th. This was the first federal legislative solution to the problem and was met with bipartisan support, passing 415 to 9. On March 1st, companion legislation, which differed slightly from the House legislation, was introduced in the U.S. Senate as the Economic Continuity and Stability Act by a bipartisan group of senators. The legislation, after undergoing a few amendments, was passed on March 11th as part of the Consolidated Appropriations Act 2022 and signed into law by President Biden on March 15th. The Board of Governors of the Federal Reserve has 180 days, so roughly until mid-September, to promulgate regulations that are implementing of this law. Next slide, please. The federal legislation, by its terms, was intended to do four things. First, to provide a clear and uniform process for replacing LIBOR on a nationwide basis in terms that for which the contracts do not provide the use of a clearly defined or practicable replacement benchmark rate. And the idea was to do all this without affecting the ability of the parties to use any appropriate benchmark rate in new contracts. So basically, come up with a system that resolves the problems of the problem contracts while allowing parties to still enter into new contracts using the benchmark of their choices. Second, to limit litigation relating to the transition in contracts that have deficient replacement language or no replacement language. Third, to allow those contracts where the parties have already agreed to sufficient replacement terms to operate without interference. And fourth, to deal with LIBOR references in federal laws. Next slide, please. So it's possible you may be thinking, well, this sounds nice, but I deal largely in contracts that are governed by New York law. What is the relationship of this law to the state laws that the various states may have passed or may pass going forward? Well, the legislation preempts, by its terms, all state and local laws regarding LIBOR replacement. So what this means is that the federal legislation will supersede those state laws to truly create one overarching process to smooth this transition, regardless of the governing law of the state. So now we have set the stage for how we got this legislation. Now let's talk about what's in it. Next slide, please. Similar to the state legislation, the federal legislation establishes as a matter of law an automatic fallback to SOFR for contracts that use LIBOR as a benchmark or reference LIBOR. So how does it do it? Which contracts does it apply to and how? Well, let's address that first question. What contracts does the legislation apply to? The federal legislation covers, this is a quote, any contract, agreement, indenture, organizational document, guarantee, mortgage, deed of trust, lease, security, whether representing debt or equity, including any interest in a corporation, a partnership, or a limited liability company, instrument, or other obligation or asset, that by its terms uses overnight, 1 month, 3 month, 6 month, or 12-month LIBOR as a benchmark. That's a pretty comprehensive listing. And it should be noted that the legislation expressly excludes 1 month and 2 month LIBOR tenors, which, as we know, are less common and also no longer being published since December 31st of last year. Additionally, the legislation expressly provides that contract counterparties may contractually agree to opt out of the legislation if they choose. So next question, what does the legislation do? Next slide, please. The first thing the legislation does is address the fallback provisions that may exist in the existing contracts. It starts by saying that if a contract has a benchmark replacement that is tied to LIBOR, or if a contract has a requirement that someone conduct a poll or collect quotes regarding interbank lending and rates, then the fallback provisions in those agreements are null and void. So then the legislation says, okay, after voiding out any of those undesirable types of benchmark replacement language, let's take the pool of contracts and divide those up into a few different categories with different treatment for each. Next slide, please. The first group is the contracts that are already good to go. These are contracts that have, by their terms, selected a benchmark replacement that is not tied to LIBOR. So for those of you who've spent any time amending your loan documents or documenting new loans that have robust fallback language, the vast majority of those will fall into this basket, assuming done correctly. These are sort of a set it and forget it arrangement where the parties have agreed to the benchmark, and it is just a matter of time to wait for the dominoes to fall to make the actual transition to the new rate. These are the contracts your institutions have marked behind the scenes as being ready for the transition away from LIBOR. The second group of contracts are those that have given a so-called determining person the power to choose a benchmark replacement. So rather than having a fixed benchmark or a waterfall, some individual will make the decision. For these contracts, the federal legislation provides that person the authority to choose the board-selected replacement, which is SOFR, and also provides a safe harbor if they choose that replacement. Now, there are three apparent outcomes here if the contract is one with a determining person arrangement. The first outcome is that the determining person timely selects SOFR as the replacement benchmark prior to June 30th of 2023. In this instance, the legislation provides a safe harbor for the decision, and any benchmark conforming changes would also be subject to the safe harbor. We'll talk about those more later. The second outcome is that the determining person makes no selection at all. June 30th, 2023 comes and goes, and no action has been taken. In this instance, the legislation steps in, and SOFR will be, as a matter of law, the replacement benchmark from June 30th, 2023 forward. Now, when SOFR is the replacement, there will also be a tenor spread adjustment, which mirrors the spread adjustments recommended by the ARC, and which also align with the ISDA spread adjustment. I'm sure many are familiar with these. I've included them in the slide just so that you can be reminded of them. And while it's possible that these may be adjusted under the regulations, this is, for the time being, what we are looking at using. Additionally, there's a special accommodation for consumer loans. In order to help smooth the transition for consumers, rather than an abrupt jump in the required spread for consumers, there is a 1-year ramp-up period wherein the spread adjustment is implemented gradually on a straight line increase to reach the applicable spread adjustment on the first anniversary of the replacement date. This avoids a sudden shift in interest rate that may be more difficult for a consumer to absorb and to adjust and plan for. The third outcome is that the determining person selects a replacement other than SOFR, such as BSBY or Maribor, etc. If this happens, the federal legislation would not have an effect, and there would be no safe harbor, but the contractual terms instead would apply as if the legislation had never been passed. Next slide, please. The third group is contracts that essentially have failed to be readied for the transition. So if contracts fit into this category, they either have no benchmark fallback provisions or have fallback provisions that exist but are deficient because they fail to either specify a benchmark replacement or do not have a determining person, that is to say, a person with the authority, right, or obligation to determine a benchmark replacement, as the statute says. So essentially, these contracts are the contracts that tried but failed to get ready for the death of LIBOR or did not try at all. For these contracts, on June 30th, 2023, benchmark replacement selected by the Board of Governors of the Federal Reserve, so SOFR, becomes the benchmark. Next slide, please. Now, as you may recall from the ARC recommended LIBOR replacement language we've spoken of in the past, the administrator of the contract has the ability to unilaterally amend the documents to make replacement benchmark conforming changes. These are changes that are technical, administrative, or operational in nature. The federal legislation has a parallel concept, but it's not exactly identical. For any contract for which the federal legislation is operative, benchmark replacement conforming changes will become a part of that contract. However, determining what constitutes benchmark replacement conforming changes is a bit more complicated. Rather than just giving absolute discretion to the contract party that is calculating the interest rate, legislation says that the Federal Reserve Board will establish what the benchmark replacement conforming changes will be. Presumably, this will come out as part of the Federal Reserve's promulgation of regulations sometime before mid-September. These provisions would become the baseline for the benchmark replacement conforming changes, and the party to the contract that calculates the interest may make any additional modifications to the extent necessary. As was the case with the ARC replacement language, adoption of the conforming changes is done unilaterally by the party that calculates the interest rate. Next slide, please. Before we wrap up, we should also touch on 3 other important provisions of the legislation. First, the The legislation contains a safe harbor provision so that parties or contracts that are affected by the legislation can't be challenged for choosing or using the SOFR rate as the fallback. This goes to the stated purpose I mentioned earlier of attempting to stem litigation relating to LIBOR replacement. The second important provision is the mandate that this legislation not create a negative inference against non-SOFR replacement rates. Essentially, the existence of the federal legislation may not be used as a sword against the validity of other non-SOFR benchmarks. Banks will be entitled to make their own determinations as to what replacement benchmark or benchmarks are appropriate for its various financial products. The legislation mandates that regulators may not take action against a bank that is based solely on its use of a non-SOFR benchmark. Now, banks still need to be able to show their regulators that they have made careful and diligent consideration of their options, but selection of a non-SOFR benchmark alone will not be a valid reason for an enforcement action. The third set of provisions are a variety of interpretive provisions, the crux of which are to make sure that the operation of this legislation does not affect the continuity of the contractual relationships that are already in place. The operation of the legislation should not be deemed to impair the rights of any of the parties, to discharge or excuse performance by any of the parties, to be deemed an amendment to the contract, a breach of the contract, or of any other ancillary effects on the relationship between the parties and the operation of the contracts. Next slide, please. Finally, you may recall that I mentioned one of the purposes of the federal law was to deal with other federal laws that make reference to or use LIBOR to bring them forward as well. And indeed, the federal legislation amends the Trust Indenture Act of 1939 and the Higher Education Act of 1965 to correct those references. In a specific application of the interpretive language I was just discussing, the legislation provides an amendment to the Trust Indenture Act to provide that operation of the legislation shall not be deemed to be an impairment on the rights of a holder of an indenture security to receive payments of principal and interest. As to the Higher Education Act, the amendments are a bit more technical and go to implement LIBOR fallback language to SOFR. So what does this all mean? Well, first of all, it's a really good solution. It'll cut way down on litigation, and it has been much anticipated. But for any of you litigators on the line, don't worry, you will still have a job and something to litigate going forward. For example, what happens if the parties disagree as to whether the contract falls within the purview of the legislation? What happens if the parties disagree as to which of the three categories the contract fits into? What if the contract is internally inconsistent? Who decides? There are literally trillions of dollars of contracts with varying degrees of sophistication that are attempting to be amended as we move closer to 2023. The sheer volume alone tells us there will be drafting errors made. So for the litigators on the line, there's certainly a chance you'll find yourself dealing with contested agreements. One other takeaway is that for institutions that are planning to use a rate other than SOFR, it will be particularly important to ensure that legacy contracts are properly amended prior to June 30th of 2023. Lest the bank inadvertently find itself with contracts that use a SOFR benchmark when they'd planned to have all their contracts using BSBY or some other rate. So with that, I think that wraps up my summary of the federal legislation, and I will hand things off to our next speaker, Joe Liniak.
Well, thank you very much, Betsy, and good afternoon, everyone. If you could go to the next slide, please. We are going to, from the East Coast to the West Coast, visit Crazy Town, because it's what the crazies in New York and the crazies in California have done, and what you need to start giving some thought to as regulations are promulgated, and you think not only in terms of your own lending operations, but also purchases of loans and related financings. And the background, and you know, I can recall back about 20 years ago, consumer groups were complaining that small businesses were really consumers. They were not commercial businesses. And they would oftentimes say, you know, the guy at the corner bodega, he has to buy or rent or do whatever in terms of a Xerox machine, and he's really not a businessman. He's really a consumer and should be entitled to all the consumer protections necessary to protect him because of his station in life. And in that regard, I guess actually as a result of it, the California financing law was amended many years ago to reflect that small business loans under $5,000 would be treated as a consumer finance transaction, which provides some additional protections as opposed to a commercial finance transaction. And so people got used to the idea of making loans in excess of $5,000, and below that, there was additional limitations and controls, including usury limitations and so forth. But nevertheless, this idea that we need to protect small businesses to a greater degree continue to percolate up, and accordingly, New York, and as Tom Kelly mentioned, the People's Republic of California adopted new lending requirements for small business loans. And frankly, this is now again moving out to other states, and other folks and legislatures are thinking about adopting the same types of protections, but it really does potentially impact a lot of areas. Next slide, please. We're going to talk a little bit, focus really on California. We'll jump over to New York, and then we're going to talk about what does this all mean in terms of disclosures to commercial enterprises. And it creates this new concept under both statutes of somebody who is a provider, really a lender, and requires them to give disclosures prior to entering into the transaction for a commercial financing. And that's a term of art in California of $500,000 or less, and it includes open-end and closed-end transactions. If you are smart enough and you can get up to around $500,000, the line of credit for an open-end line of credit should be $500,000 plus one in order to get outside of this box. And again, provider means a person who extends a specific offer of commercial financing, again, a new term of art, to a recipient. It also includes third parties, arguably fintech companies, that introduce the borrower to someone who originates the loan, and so therefore they may be covered. And again, trying to cover, to include as many folks as possible into this category. Next slide, please. Now, a commercial financing, and this is an important concept, is there's several different things. It's a closed-end loan, it's a commercial open-end credit plan, it's an accounts receivable purchase transaction, including factoring, asset-based lending transaction, or lease financing transaction. But those are included, but they're not exclusive. So theoretically, understanding what the author did when this was drafted is that if you think you're in a commercial financing transaction, then you've got to comply. And again, I think there's going to be a couple of defaults that will apply, but you can't get out of it by simply saying, well, we're a little bit more nuanced and don't quite necessarily meet these specific transactions. Again, something which we got to look at. And the California Department of Financial Protection and Innovation has proposed regulations identifying the disclosures necessary for these identified categories. And again, they apply to financing transactions that are primarily for other than personal, family, or household purposes, which is kind of goofy, but we've come 180 degrees. Next slide, please. Now, there's exemptions because you can imagine that traditional institutions went to war on these requirements. And several important ones were exempted. A depository institution, meaning just about every category of banks, federal savings banks, credit unions, and also in proposed regulations, subsidiaries of depository institutions. And so that's a good thing. It doesn't necessarily address buying these loans that are subject to this requirement, and we'll talk about that in a moment. Other components, entities subject to the Farm Credit Act, a commercial finance transaction secured by real property. So real property transactions where you take a security interest in real property, you're going to be exempted. But if you take a security interest in something other than real property, and it's a financing transaction, you're going to be covered. Also, they threw in the exemption in the California financing law, which is that if you make one commercial transaction in a 12-month period, or 5 or fewer commercial transactions in a 12-month period that are, quote, incidental to the business of the person relying upon the exemption, you're exempt from the loan. Now that second clause, 5 or fewer commercial financing transactions in a 12-month period, no one knows what that means. It is absolutely, somebody was probably smoking when they wrote it. It's in the statute. But anyway, there's a possible exemption in a minor series of transactions if you have to take advantage of it, and so forth. Next category, please. The CDFBI has issued unbelievably complicated and probably flawed regulations to implement this new law. They issued it on September 11th, and then they realized that everyone was howling, and so they tried again on April 7th of 2021. More howling, and they did it again on August 9th, and again on October 12th of 2021, and of course they did it one more time on November 5th, 2021. And you can go take a look at them, and the industry trade groups have pointed out all sorts of flaws in this whole thing. And at the end of the day, what's really important here is that they have attempted to create, probably without the technical expertise to be able to do so, TILA-like disclosures for open-end and closed-end lending for a commercial transaction that must be delivered to a borrower before consummation. And the primary components, again, everything is in reference to the Truth in Lending Act. You have to provide the APR, the finance charge, and the formatting of what disclosure is being given. I will also say to you, and something which has yet to be decided, and this has been confirmed by both the New York and California regulators, it is unclear what the penalty is. Clearly, there can be enforcement by the New York Department of Financial Institutions and also by the California CDFBI. But whether or not this means that you can use like 17,200 in California, the California Consumer Legal Remedies Act, or the California version of UDAP in order to go after someone that technically violates this law remains to be seen. And it really is a significant issue if you're thinking about buying loans. Next section, please. In New York, to show the fact that they were rougher and tougher than California, California set up their financing transaction ceiling at $500,000. New York went back and said, no, that's the wrong number. It should be $2.5 million. That is a very, very big number. And they also addressed the same types of issues of the types of categories, but not the exclusive types of categories that apply. Sales-based financing, so that would be retail installment sales, closed-end financing, open-end financing, factoring, lease financing, and again, the difference between a true lease and a financing lease, and general asset-based financing. Initially in the legislation, it was immediately effective without the necessity of issuing regulations, and you can see how in New York people screamed, and they amended it and issued an interpretive letter saying, we've got to issue regulations because there's a lot of things here we have to deal with. Also, they've concurred in the fact it is unclear as to whether or not what the remedies are for individuals who have been injured as opposed to enforcement action taken by one of the regulators. Next slide, please. And if you, by analogy to truth in lending, you can probably sit down and, for those of you who are consumer groupies, come up with the types of things that would be disclosed in a consumer contract context. The total amount of the commercial financing, the disbursement amount, also known as the amount financed. And unfortunately, Senator Jake Garn died about 2 decades ago. He's the only person that ever really understood what the amount finance was. And so, but anyway, we still have to compute it. The finance charge, the APR, the repayment amount, the repayment schedule, all potential fees, refinance terms, collateral requirements. It's a real load of things that have to be disclosed. And let's now go to a representation of what might this thing look like. Next slide, please. Utilizing the California draft regulations, the final ones, this is what's got to be disclosed before you agree to a loan with a or financing with a borrower who falls within this category. There's all sorts of fund disclosures. It looks very much like a truth in lending closed-end disclosure. And in the other categories that we were talking about for receivables financing and for these other categories, in each case, the New York and the California regulations add additional categories of things you've got to disclose. And so you're not only talking about a closed-end disclosure, you're not only talking about an open-end disclosure, you're talking about maybe 10 or 12 different individual fine-tuned disclosures that have to be disclosed to people and for commercial financing, and it must be disclosed before you finalize the loan. And of course, the next slide is the Jake Garn amount itemization of amount financed. And whatever this means, it means, and however you calculate it, you've got to calculate it, but you've got to give it. And talk about somebody in a bodega not being able to understand what it is that they're receiving. Maybe we need to also require counseling in order to be able to have somebody explain this to folks, because I've never been able to, and thankfully they never asked me to explain it to people. But it's been included and it's actually in the regulations. Final next slide, please. A couple of observations. When you think about what's being potentially required, and by the way, to digress for a moment, the California folks have indicated that it's probably going to be the end of this year when these regulations, if they're actually adopted in the final set of amended proposals, it'll probably be the end of this year before they are become effective. And thankfully, they're not effective until after they're finalized. I will say that there are, when you look at this, all of these types of loans, these small dollar amount transactions, which are, again, the Xerox machines, the cash registers, and all of these things, they're done on an automated basis. Well, that's probably going to go away, or on all the automated functions, what's going to have to be built in is this disclosure, which is going to have to fine tune what has been negotiated with a covered person, a small commercial borrower. And there may be several iterations if the negotiations continue on. You apparently have got to give several different updates leading up to the final one before you close your transactions. Now, for those of you in bank land, you're sitting back saying, well, it doesn't apply to us. Well, that may be true, but when you read over the language about in which they adopt all of the truth in lending rules, whether or not those rules likewise will come over and apply is unclear. But one of the things which I think everyone will need to deal with is our friend assignee liability, and whether or not, if you buy the loans from a provider, whether or not assignee liability will apply to you, and what does that mean? And will it stifle the ability to end up buying loans as opposed to originating loans? The converse may also be true. There may be banks that see this as an opportunity because they're not going to be subject to these rules. And so therefore, in the marketplace, there may be an opportunity to be able to go after small businesses in a manner where heretofore they were was not available. And again, folks who think about this, it may be attractive and a competitive advantage. So this is going to be pretty significant over the next several months as these regulations get finalized. We'll see whether or not vendors come up with automated systems in order to be able to expedite the system. But again, very, very complicated, very, very complex. I would give both the Department of the New York Department as well as the California Department a C- in terms of the quality of what they wrote. And we're probably going to have to do a lot of work in order to get them up to speed in terms of putting together something that is compatible and is workable for the industry. So again, thank you for visiting Crazyland. We are now at the end of our time, and I will turn it over to Tom.
Only if I can unmute my phone. Thank you, everybody, for attending. We will be having another roundtable in May. Topics on that will be forthcoming, and I look forward to seeing you again next month. And I hope this has been helpful. Have a good day.